member of the public, he's entitled to demand information from the authorities on anything, and he'll be armed with that act, which will give him the power to demand the information.
What information would one then have access to?
He will have access to any information, provided it is not information that can put the security of the country into jeopardy. Basically, you can the authorities will be bound by the provision of the Act to disclose whatever information that any person would want, provided, of course, it is not precarious or it does not endanger the national security of the country. You realize that in all this, in every disclosure, there is a limitation on security. If anything can be deemed to be a security risk in disclosing it, then surely the authorities will be within that power not to disclose such.
Other countries, what measures have they taken to ensure that this problem of conflict of interest is minimized at business level and at government level?
Yes, in other countries, you realize that they have several acts or acts of parliament which seeks to address this issue of conflict of interest. Firstly, they ensure that the definition of conflict of interest is wide enough to capture a lot of people, being politicians, public officers, employees. The definition is expanded in such a way that it captures everybody who can find himself in a situation where conflict would reasonably expected to occur. And you find that really conflict of interest is basically corruption. It's one little facet of corruption. And the question would be, what has other countries done to ensure that they combat conflict of interest and, by extension, corruption? They've come up with such laws as laws dealing with declaration of assets by public officers, particularly those in decision-making positions such as ministers, judges, magistrates, people who have influence in the procurement system of government. And basically, if you disclose to the public, what matters is to whom do you disclose. You must disclose to the public your full interests, assets and liabilities. We do not have evidence of any corruption. At the time when you got into office, you had declared full interest, let's say your assets, your liabilities, and we know from that public document that you have assets amount to 1 million pula. And 5 years down the line, you exit your office, we realize, we go to the register, we found that no, you are not worth 100 billion pula. You see, we are now going to ask you, where do you get the 1 billion pula? Because just 5 years ago when you got into office, you were worth 1 million pula. That's an effective way of combating corruption. And the people involved will realize that everything that I do is in the public domain, and so long as in the public domain, we're bound to have somebody questioning this discrepancy. How did you acquire so much riches? Then it will give us enough leads to probe further into affairs. And you see, there may be instances where you have the scenario that I've described, but you will not be able to find corruption easily. What other countries have done in such situations, they have come up with legislation called such as asset forfeiture legislation. It is not under which you don't have to prove any criminality. You just have to go to court as the director of public prosecution and say, look, the minister so-and-so has assets, which assets are far in excess of what we know him to have been earning. we have reason to believe that he illicitly got this asset, then the court will issue an order forfeiting those assets to the state. You see, it's quite different from what we currently have in Botswana. What we currently have in Botswana in terms of proceeds of Serious Crime Act is that everything, any seizure of assets is closely linked to a criminal offense. That is, the state would have to prove a criminal offense against you as the basis for them
to seize your
seizing your assets. But then, in terms of this legislation, asset forfeiture legislation, it is just one of the countries with such legislation in South Africa. See, you don't have to go to court and prove any criminal wrong. And we mustn't forget the fact that, when you prove a criminal offense against anybody, the standard is too high. The standard of proof is beyond reasonable doubt. It's such a high standard of proof. But when you deal with a suspect or an individual under the asset forfeiture legislation in South Africa, you don't have to prove your case beyond reasonable doubt. You prove your case on a balance of probabilities, which is basically a lower standard of proof. That was specifically designed to ensure that we'll actually extend the long hand of the law to even those who are so scrupulous that they can engage in corrupt practices and in such a manner that they cannot easily be detected.
Is it a fair law?
Of course it's a fair law. I want to believe that if you know you are clean, you should be able to tell us, where do you get 10 Range Rover Sport? Where do we have 10 farms? Where do we have, whereas your past known income does not justify it? I mean, if you know you are straight, you are fair, you should be able to answer those questions easily, and you should be able to vigorously oppose any application by anybody, be it DPP or private prosecution. Otherwise, if we are going to run away from this on the basis of fairness, then surely we will fail dismally to fight corruption.
Going back, Busang, to declaration of interest. Somebody declares their interest in writing, like you said. What then follows?
Okay. Once you declare your interest to the authority in writing, then the authority should take a decision whether he allows you to take part in the proceedings, which should be determining, say, a tender in respect of a company in which you have interest. Then the law does not make it mandatory that the permission by the authority should be either in writing or verbal. I take it that the authority can, in view of the fact that the request in writing, it only makes sense that the response must be in writing. The response by the authority permitting you or declining to permit you to take part should be in writing.
Busang, thank you very much for your time.
And most